Hello and welcome to Legal Basics with Sarah Global, and my name is Sian. Today, still on the intellectual property series, we're going to deal with a form of intellectual property that is confidential information. Contrary to popular belief, confidential information as a form of intellectual property is actually not new. It has been protected under several international instruments, including the Paris Convention that is as old as 1883. Now, for a business to have intellectual property in confidential information, as opposed to general confidences, it has to have some value that it gives to the business, and this value must be a commercial value. Now, confidential information could be pertaining to things that are very simple. It could be the database. It could be the criteria that the business uses. It could be the client information. All these things can be classified as confidential information. However, this is the threshold for a piece of information to qualify as confidential information as intellectual property. Number one, this confidential information must be generated through the mental effort of the owner or of the business. But this will also include people that have been contracted by the business to generate this kind of confidential information. Secondly, confidential information is protected as intellectual property if it gives the owner some commercial value. Now, information can be protected as confidential information, and it can also be protected under a copyright. Remember, in our previous broadcasts, we explained that copyrights do not need to be registered for them to exist. So, information, for example, a certain way that a business keeps its database can find protection under confidential information, and it can also find protection under a copyright. However, if the information is so novel, so unique that it amounts to an invention, then a person has to choose between confidential information and registration of a patent. Why? Because essentially, when a person registers a patent, they have to reveal all the details of their invention in exchange for having exclusive rights of exploitation of the invention. However, for confidential information, it is important that this information is not divulged to any other people, or it's not known to the public. However, sometimes for businesses to operate and to apply this confidential information to make profits, they are forced to divulge this information to other people. Sometimes these people are their employees, sometimes it is business partners, and sometimes it is in the course of consultancy. So how does a business protect itself from having their confidential information divulged to the public? Number one, always inform the person that is being revealed to that this information is confidential, and you have to tell them that they have a duty to confidentiality. Second, let the information be labeled. It could be in places that have restricted access. It could be in soft copy files that come with a password. It could also be unwritten, so long as it is communicated in a situation of trust, and it must be expressly labeled, or the person being told must be told that they have a duty to keep the information as confidential. Now, unlike other forms of intellectual property, confidential information can be protected even before it is infringed. So what does this mean? It means that a person who owns confidential information can move to court to stop another person from divulging that confidential information. So how does this happen? In that course of business where you have to share some of your confidential information with your employees, or with your partners, or with a fellow consultant, you have to have an NDA, which is a non-disclosure agreement. So usually that non-disclosure agreement will say what information should not be disclosed, and some employment agreements will stop their employees from working for competitors. So now, in the event, for example, that this employee leaves place A, where there was an NDA, a non-disclosure agreement, and wants to go and work at place B, which is a direct competitor of place A can go to court and stop this person from working for their competitor. However, when you do draft contracts that have a non-disclosure agreement, and especially where there's a restraint, where a person is not allowed to work for a competitor, you need to have your lawyers draft very, very carefully, because at the end of the day, the right of a person to earn a living will always supersede the right of a business to keep its secrets. So when you do draft your non-disclosure agreements, or when you do have any provisions that restrain a person from working for your competitors to protect confidential information, you have to be careful such that it does not overly restrict them to a point where application of that restriction would be unreasonable. Because at the end of the day, your employees, even after they leave your place of work, will have a right to earn a living. So, I hope this broadcast has been useful to you. If you have any kind of information that you feel gives you an edge in the market, you need to keep it safe. You need to ensure that your contracts contain non-disclosure clauses. You need to ensure that your information is labeled as confidential. You need to ensure that you have passwords, because if that time comes when you have to protect your intellectual property, you must prove as an owner of the confidential information that you have taken all reasonable steps to keep such information as confidential. I hope that this was useful to you. We will wait for your questions. Please write to us at saralowglobal@gmail.com. Bye-bye. Take care.